about the competition compliance, and one realized how very few corporates in India actually have a competition compliance program. Let me share a small thing with the House here today. One of our leniency applicants actually, in fact a couple of them, have pointed out to us that it is because of their in-house competition compliance programs that they were able to unearth the existence of a cartel. And then they came to us with leniency applications. So maybe Sundar got in touch with some very top 10 or maybe whatever, where only one was having a competition compliance program. But it is indicated that probably there isn't enough that is done in this end.
I will just clarify, it was of the pure Indian companies. MNCs, I found the data to be better, 6 out of 11. But when you look at pure Indian companies, who have Indian promoters, traditional Indian companies, that advantage is wrong. Which is right.
So obviously compliance leads us to leniency, and let me talk a little bit more on leniency, because I think the other panelists would speak more on the compliance part of it. And as far as leniency goes, we all know that it's very difficult to crack hardcore cartels today. It's increasingly becoming difficult to find the smoking gun. And so what you would be looking at is leniency applicants. We had a few officials from the US FTC and the DOJ who came a couple of months back to the CCI for a certain workshop. And they shared with us one statistic. They said more than 90% of the cartel investigations in the US emanate from leniency applications. So, and that's why they have a high success rate. There are other reasons also for that success rate, which I will probably come to later. But that is very important. This sort of culture is still to come in our country. But let me say one thing, that it's increasing, fast increasing. In my introduction, I had said that I joined in February 2013, and soon after that, we had the first leniency application in the CCI. Thereafter, let me share with the House that we've had a number of leniency applications. These involve leniency applicants who were parts of international cartels and home cartels also. They cover various sectors. I also want to share that these are not all of them are cases where they are the ones who assisted the CCI to form a prima facie case. That is, we had no clue about the cartel, and since the applicant came to us, the LB applicant is the one who enabled us to form a prima facie case regarding the cartel. In addition, we have other applicants who have come to us in course of the DGA investigations. You all know that as per the regulation, provisor to regulation 4, I think, you are allowed to come in if there is a cartel investigation on. The applicants, the participants of the cartels can come to us and file a leniency application anytime before the DG presents his report. So we've had both these kind of leniencies. In the mature jurisdictions, they call it the type A, type 1 and type 2 types, but we don't call it. We just say leniency applications under the regulation or provisor to the regulation. That is before the prima facie or on an ongoing investigation. Just to bring home the fact that we have leniency applications of all types. The profile is varied. Since I find lots of people in this room who are hands-on, they would know that you can make an oral contact, email, phone call, and we note down in the secretariat, we note down the time of the call, the date, etc., date, time, etc. And we move the file for a marker, we bring it before the commission, and our regulations allow, the lesser penalty regulations, allow 3 markers. The first marker is to the first applicant, the first to the door, who gets and can get a leniency up to 100%. The second and third, it's 50% and 30%, up to 50%, up to 30%. This is quite unlike, say, the US, where there is only one marker who gets 100%, period. There is nothing like up to 100. So that is because if I go to substantive section, that is section 46, there are 3 important words over there. It's full, true, and vital. And so you have to make a full and a true disclosure and a vital disclosure. Interestingly, the section doesn't discriminate between the first, second, and third applicant. That means the full, true, and vital applies to all three, all the people who come, first in line, second in line, third in line. It is the regulations who then say there's a first marker, second marker, third marker. And for the second and third marker, the additional words that are used are substantial value added. So it's not just value added, it has to be substantial value added. So that is the basic architecture about markers. Once we give the marker, we're given a 15-day window to actually come up and give details about the leniency application that you made. And that details are listed as per the schedule with the disability applications. Here, let me just share with you a small practical difficulty that we face. And maybe in the earlier applications, those were early days, and the kind of information that came up to us, we did form certain prima facie orders were passed, and in 26 months investigations were directed. But probably they were in the process of culling out that information, and it was kind of half-baked. So the DG is now grappling with those issues, because what has happened is that the leniency participant, then the leniency applicant says, okay, I've got my first leniency marker. I've enabled you to frame the 26 order, and so now that's it, I don't have anything more. But probably what we need to go back is to the Act, is that the Act also talks of continuous cooperation, which is very essential to the markers. So marker is a very, very sort of a provisional position. Finally, when it comes back and the DG report comes to the Commission, all of this would be evaluated. So it's very important for the leniency applicants to be very responsible in the entire process. So that's the issue of the markers. And Karan, you had asked me to also speak about confidentiality and inspections. So if I have crossed my time, maybe I'll leave that for later.